is the first lecture of the series organized by Advocate on Record Examination Cell. And the first paper is Practice and Procedure. So the first lecture is also Practice and Procedure. Now, what is practice and what is procedure? Practice is the jurisdiction of Supreme Court. What kind of cases can be filed in Supreme Court? That is the practice. If a client comes to us, how will you invoke jurisdiction of Supreme Court? That is part of the practice. And what is the procedure? What is the form which will be filed? How are the pleadings drafted? What are the affidavits? What are the certificates required? How is the wakalatnama to be executed? How is e-filing done? These are all manner of procedure. Therefore, practice and procedure is a very important paper, and it is heart of our syllabus. Now, first I would like to discuss the practice part, which is the jurisdiction of Supreme Court. And there is a short note which is displayed. Are you able to see examination hall?
Pictures of putting the entire plan field. Anyway, all the best.
Is the short note visible?
Face this difficulty, we are aware. So we are really not after because as brother has said, you have your own difficulty.
Okay, so it is visible.
But at the same time, this translation.
So as we see,
Exactly. More.
That's right. Right. So,
Thank you.
If I may just
अबे नेटवर्क क्यों चला गया?
started from scratch. The Lordship showed us the way, and we are at least we can say something that we have achieved end of it. All due to your Lordship's guidance. Thank you, sir.
133 appeals lie if the High Court certifies under Article 134A that the case involves substantial question of law of general importance. Now, there is a distinction between two. What is substantial question of law as to the interpretation of Constitution? Interpretation of Constitution would mean, for example, in Sabrimala case, where a woman's right to visit a temple was challenged on the basis of Article 14 and 15 of the Constitution. In such case, it would be an interpretation of Constitution, substantial question of law as to the interpretation of Constitution. What is the case which involves substantial question of law of general importance? Now, a substantial question of law, 1 minute, sir. Yeah. Of general importance is a question which will not only affect the parties, but will be of large ramification. So these are the appeals under Article 132 and 133. Then we move forward and we see appeals which are under the statutes. Now what we have done is, we have also given corresponding orders. So there are orders which are mentioned for appeals arising out of statute or any other law for the time being in force. The orders are mentioned in the note, and there are quite a few appeals which are statutory appeals, and I will just rush through them. One is the appeal under Section 35L of Central Excise and Salt Act, appeal under the Consumer Act of 1986, and now under the Act of 2019. There is a typo here. It should be 2019. Then appeal under Section 19(1)(b) of the Contempt of Court Act, appeal under Section 38 of the Advocates Act, appeal under Section 116A of the Representation of People Act, appeal appeal under section 261 of the Income Tax Act, appeal under 53T of the Competition Act, and under the Electricity Act. Now, there are a few more. I need not read through them, but these are only illustrative. There are few more statutes where appeals directly lie to Supreme Court. But the point is, all statutes have a different provision. There are certain statutes which provide that appeal would lie against a question of law only. However, there are certain statutes which will provide that appeal would lie against substantial question of law. Now, what is the difference between a question of law and a substantial question of law? An interpretation of a document is a question of fact. But if there is a legal effect to a term of a document, that would be a question of law. So let us give an example. For example, in an agreement to sell between a builder and a purchaser, there is a clause which provides that if the purchaser fails to pay the entire consideration, the advance money paid will be forfeited. Now, an act of forfeiture is a question of fact. If there is a default, and an act of forfeiture is a question of fact. But can a builder forfeit the entire amount of advance on the pretext of section 73-74 of Contract Act? That would be a question of law. So appeals would lie under few statutes on a question of law, and under few statutes, appeal lies to Supreme Court only on a substantial question of law as per section 100 of Code of Civil Procedure. Is the note not visible? Because I just got a message that it is not visible. Okay, thank you. Yes, thank you. Now, what is a substantial question of law? The Supreme Court has time and again specified what is a substantial question of law, but I would like to draw attention to a recent judgment which is reported in 2022, SCC Online, page 1273, case of Chandrabhan. The citation is 2022, SCC Online, page 1273, where the Supreme Court has held that a substantial question of law would mean that the question is not decided by the court so far, or a question of law which is already decided has been ignored by the court below. In both the cases, it would be a substantial question of law. So we have illustrated about 16 statutory appeals which can be filed before the Supreme Court, and the corresponding orders are from Order 19 to Order 24 of the Advocate Rules, Supreme Court Rules. Sorry. Now, there is a third category of the appellate jurisdiction, that is appeal under Section 2 of the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act 1970, read with Order 20 of Rules. Now, which are these appeals? For example, an accused is acquitted by the Session Court, but accused is convicted to life imprisonment by the High Court. In such case, accused has a right of appeal under Section 2 of the Supreme Court Enlargement of Criminal Appellate Jurisdiction to the Supreme Court. Now, I just at this juncture would like to add that under Article 134, also an appeal would lie to Supreme Court if the High Court has reversed the acquittal and has given conviction of death sentence. So if the conviction and imprisonment is death sentence, then Article 134 appeal would lie. But if the conviction on reversal by High Court is of life's imprisonment, then appeal under Section 2 of Supreme Court Act. Then item 4 deals with appeals upon grant of special leave to appeal under Article 136 of the Constitution, and the relevant orders are Order 21 and Order 22 of the rules. If the special leave petition leave is granted, then as we all know, would get converted into appeals. So the first topic which we have covered is the appellate jurisdiction of Supreme Court. Now let us see what is the extraordinary appellate jurisdiction. Now this is the bread and butter and favorite of every lawyer. That is a petition under Article 136 of the Constitution, and the relevant orders are Order 21 and Order 22. And as we all know, any order of any tribunal, any court or High Court can be challenged under Article 136 of the Constitution. However, there is an exception which you will notice in sub-article 2 of Article 136. I suggest you may go through it so you are aware as to in which case an SLP cannot be filed under Article 136 of the Constitution. Now let us see what is the original jurisdiction. Now, as we all know, petitions filed under Article 32 of the Constitution, read with Orders 38 of the rules for issue of directions, orders or writs, including there is some note just come. Including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. A writ is filed under Article 32 for enforcement of fundamental rights. Now kindly note, there is a distinction. When we file a petition under 226 before the High Court, it is for enforcement of your legal right. Whereas under Article 32, we file petition for enforcement of fundamental right. Now I'm getting some messages that the voice is not clear. Examination cell, is it clear?
Yes, sir, you are clearly audible, sir.
Okay, because I'm getting some messages, maybe their system is not clear. All right. So we'll move ahead. First jurisdiction we discussed is Article 32. Then item 2 deals with original suits under Article 131 of the Constitution, and the relevant orders are 25 to 37. The Supreme Court has original jurisdiction in any dispute between Union of India, that is Government of India, and one or more states, or between two or more states. There is, however, an exception, that is Article 262, which states that if the Parliament by law has provided for adjudication of dispute with respect to interstate river, in such case, Supreme Court will not exercise jurisdiction. So if there is a law enacted by Parliament to decide, for example, Kaveri water dispute, if there is a tribunal set up, a law is provided, then original jurisdiction will not lie. Now, recently Supreme Court examined whether it can exercise original jurisdiction in the case where state of Chhattisgarh had challenged the central legislation of Union of India on NIE Act, that is National Act. So original jurisdiction was entertained. Similarly, state of Kerala had challenged the Citizen Amendment to Citizen Act before the Supreme Court by way of original jurisdiction, which was held to be maintainable. So it is not just dispute between Government of India and state, it also includes challenge to a statutory provision or a statute by a state against Union of India. Now, let us move ahead. What is the third category of original jurisdiction? Under Article 139A(1) of the Constitution, read with Order 40 of the rules, seeking transfer of cases involving same or substantially similar question of law pending before the Supreme Court and one or more High Court, or before two or more High Courts. So in exercising jurisdiction under 139A1, Supreme Court will transfer the case to itself. Now, this has happened in a recent case, which is currently going on before the bench of Justice Pardiwala and Justice Madhavan, where the challenge is to a various provisions of the GST Act on the online gaming. Various petitions are filed before the High Court and also 32 petitions before the Supreme Court. So Supreme Court has transferred all those High Court petitions to itself in exercise of Article 139A1. Now, under Article 139A2, the Supreme Court can transfer any proceeding before any High Court to any other High Court. Supreme Court also exercises jurisdiction under Section 25 of the Code of Civil Procedure, read with Order 41, for transfer of any suit, appeal, or other proceedings from a High Court or other civil court in one state to a High Court or other civil court in any other state. Now, we must have come across various cases daily that a matrimonial disputes are being transferred from one state to other state, from one civil court to other civil court, from one family court of a state to other family court of a different state. Now, there is an exception. For example, if there is a transfer you are seeking from the state of Punjab to state of Haryana, though they are different states, you will not file a transfer petition in Supreme Court because there is a common High Court, which is Punjab and Haryana High Court at Chandigarh. So in such case, the transfer petition will be filed only at Chandigarh. Similarly, Guwahati High Court has jurisdiction which extends to 4 states, that is Assam, Nagaland, Arunachal Pradesh, and Mizoram. So if a person is seeking transfer interstate these 4 states, he will not come to Supreme Court. He will be advised to file a transfer petition before the Guwahati High Court. Now let us see transfer petitions which are seeking transfer of criminal matters. Section 406, which was CRPC of 1973, and now it is 446 of BNSS, read with Order 39, seeking transfer of any particular case or appeal from one High Court to another High Court, or from a criminal court subordinate to one High Court to another criminal court of equal or superior jurisdiction subordinate to another High Court, then you will come to Supreme Court. If it's an old case, then under Section 406. If it is after the amendment, after the enforcement of new act, then it will be under 446 of BNSS. You will be invoking original jurisdiction of Supreme Court. Then we have petitions which are challenging presidential and vice presidential election, read with Article 71 of the Constitution, and the relevant orders are Order 41, which disputes relation to the election of a president or vice president. Then the original petitions will be filed. Similarly, the last entry in the list of original jurisdiction is of petition under Section 11(5) of the Arbitration and Conciliation Act 1996, read with appointment of arbitrators by Chief Justice of India scheme of 1996 relating to appointment of an arbitrator. Now, in an international commercial arbitration, the original jurisdiction is with the Supreme Court. If it is not international commercial arbitration, then we have to go to the High Court for appointment of an arbitrator. So the original jurisdiction for international commercial arbitration is under Section 11, subsection 5 of Arbitration and Conciliation. So we have 8 categories of original jurisdiction, which we have discussed. that is petition under 32, suits under Article 131, then petitions seeking transfer under Article 139A1, petitions under Article 139A2, then transfer petitions under Section 25, transfer petition under Section 406, now 446 of BNSS, challenge to the presidential, vice presidential election, and appointment of arbitrator in case of international commercial arbitration. Now let us consider what is the extraordinary original jurisdiction. Now petitions which are filed in the nature of PIL, that is public interest litigation, we have categorized as extraordinary original jurisdiction. Why it is extraordinary original jurisdiction? Because it is seeking a relief in the nature of public interest litigation. Order 38 is very relevant because it prescribes a complete procedure as to how you should invoke a PIL when you are approaching Supreme Court. Interestingly, there is also Article 32 invoked if you are seeking a transfer of a case involving state of Jammu and Kashmir in furtherance of your right to access justice under Article 21. So if a citizen feels, that his case is not being heard before the state of Jammu and Kashmir, he can file an Article 32 petition seeking transfer to the Supreme Court. Now the next category is advisory jurisdiction. So we have discussed appellate jurisdiction, original jurisdiction, and extraordinary original jurisdiction. Now, what is advisory jurisdiction? The first subcategory of advisory jurisdiction is referenced by President under Article 143, 1 of the Constitution, read with Order 42 of the rules on a question of law or fact of public importance, then reference under 143(2), which of a dispute of a kind mentioned in the proviso to Article 131 of the Constitution. Now let me pause here for a moment. We all must have read that recently President has made a reference to the Supreme Court with regard to the governor's power and President's power on the timeline framed by the Supreme Court in a Tamil Nadu governor's case. Justice Partiwala and Justice Madhavan, in a recent judgment, in exercise of power under Article 142, has laid down certain guidelines, including certain time frame for the governor to pass bills pending before it. So in this context, the President of India has made a reference to the Supreme Court under Article 143. Then the third category is reference by a President under Article 317 in relation to an inquiry for removal of a chairman or any other member of Public Service Commission from his office on the ground of misbehavior. Now, this is not all. There are other statutes which also provide for references. So reference can be made by a President under Section 14 of the Right to Information Act if a Chief Information Commissioner is sought to be removed. Similarly, a reference can be made by the Governor to the Supreme Court under Section 17 if the state Chief Information Commissioner is sought to be removed. References can also be made under Section 257 of the Income Tax Act, read with Order 45 of the rules by the Income Tax Appellate Tribunal, and also under the Competition Act. So there are various provisions under which a reference can be made to the Supreme Court, and Supreme Court will then exercise its advisory jurisdiction. Now, let us see the last column, last part of the jurisdiction, which is inherent and plenary jurisdiction. The inherent jurisdiction would involve contempt petitions. Now we have categorized contempt petitions into civil and criminal. Now a petition under Rule 3 of Rules to Regulate Proceedings for Contempt of Supreme Court 1975, read with Section 2B. Now 2B is a civil contempt of Contempt of Court Act, read with Articles 129 and 142 of the Constitution, shall be registered as contempt petition civil. Similarly, a petition under Rule 3 of the Rules to Regulate Proceedings for Contempt of Supreme Court, read with Section 2C, which is a criminal contempt, shall be registered as contempt petition. Now, this is the inherent jurisdiction. And what is plenary jurisdiction? Article 142 of the Constitution gives very wide power to the Supreme Court for doing complete justice in a cause or in a matter. Now, on various occasions, Supreme Court has invoked Article 142 to do complete justice in a cause or in a matter. A recent example one can see where the Constitution bench said that a divorce in case of irretrievable breakdown, even though is not a ground for divorce under the Hindu Marriage Act, can be granted by Supreme Court in exercise of its jurisdictional power. Article 142. A case that was a case of Shilpa Shailesh versus Varun, where Justice Sanjeev Khanna, the former Chief Justice, as he then was had authored the judgment. Similarly, a recent judgment of Supreme Court in the case of Tamil Nadu Governor's power, the bench of Justice Pardiwala and Justice Madhavan exercised Article 142 to lay down certain time frame for passing of the bill. There are various cases you will find where Supreme Court has exercised power under Article 142. In fact, in one of the cases, even in a commercial dispute, that is Delhi Metro, Supreme Court had set aside the award of an arbitral tribunal. I have my reservation whether Supreme Court could have exercised its curative jurisdiction to do so. However, the Supreme Court in its wisdom had exercised its curative jurisdiction. So these are the various jurisdictions which Supreme Court invokes. Now let us examine what are the benches which are constituted by Supreme Court. First, we will discuss single bench. When is a single bench deciding what kind of matters? So under Order 5, Rule 2, we will find hours of the court in relation to matters which are exercised by single judge sitting in chambers. So when you see the Supreme Court rules, you will find various powers are exercised by single judge sitting in chambers. It does not go before the court, before the division bench. There are certain powers which are exercised by registrar also, which also you will find under Order 5. Then, in exercise of power conferred under Order 2, Rule 6 of the rules, the Chief Justice may direct matters of urgent nature to be heard by a judge sitting singly during summer vacation or winter holidays. So in vacation, the Chief Justice can delegate the power to hear the matter even while sitting singly. They are not in that case sitting in chamber. Now, item 3 is little important because it deals with the recent amendment. The Supreme Court rules of 2013 were partially amended by the rules of 2024. Now, Order 2 of the Supreme Court rules is substituted, and instead of vacation judge, the first partial court working days is substituted. Further, Order 38, Rule 1 is substituted, Now, petition under Article 32 will be heard by a court of not less than 5 judges, provided that petition does not raise substantial question of law as to interpretation of Constitution. In that case, it will be heard by a court of less than 5 judges, and during partial court working days by a judge sitting singly. Therefore, the amendment is that Article 32 petition, if it involves substantial question of law as to interpretation of Constitution, then it will go to 5 judges. The example which we were discussing, a right of Sabrimala judgment, a right of a woman to visit temple, Article 14-15 violated. If a petition was filed under 32, it will be heard by 5 judgments. The Ayodhya land dispute, heard by 5 judgments, because it discussed violation of fundamental rights, religious rights, as well as property rights. Then, what are division benches? Under Order 6, Rule 1, subject to other provisions of the rules, every cause appeal shall be heard by a bench consisting of not less than 2 judges. So, as we normally see on an admission day, there are benches of 2 judges. Then every cause, appeal or other proceedings arising out of the case in which a death sentence has been confirmed or awarded by a high court shall be heard by a bench consisting of not less than 3 judges. So please note, if it's a question of granting death sentence or confirming death sentence, the strength of the bench should be 3 judges. Now, in exercise of power under Order 2, Rule 6, the Chief Justice may direct matters of urgent nature to be heard by division bench during vacation. Now, what matters are taken by Constitution bench? Every case involving substantial question of law as to interpretation of Constitution under Article 145(3) or any reference made under Article 143 shall be heard by a bench consisting of not less than 5 judges. So the example which we discussed about Tamil Nadu governor case, a reference made by the president will be heard by a bench not less than 5 judges. Similarly, every petition calling in question the election of president or vice president under Article 71 of the Constitution, read with Part 3 of the Presidential and Vice Presidential Election Act, shall be posted before the bench of 5 judges. Chief Justice may from time to time constitute the bench of 5 or more judges for the purpose of hearing any other appeal. Now, when are the references done to the larger bench? A division bench of 2 or more judges may refer any cause, appeal, or other proceedings pending before it to a larger bench of not less than 5 judges involving substantial question of law as to interpretation of Constitution, which we discussed. Now, where in the course of hearing of any cause, appeal, or other proceedings, if the division bench considers that the case should be dealt by a larger bench, it shall refer the case to the Chief Justice, who will then constitute the bench for hearing it. If the bench of less than 3 judges hearing a cause, appeal, or a matter is of the opinion that the accused should be sentenced to death, then it shall refer the case to Chief Justice, who shall thereupon constitute the bench of less than 3 judges. Now, after the reference is answered, the case shall be placed before the Chief Justice for listing before the appropriate bench. The next category is review petition. A review application for review under Order 47 of the rules. In fact, even under CPC, it is Order 47. And so under Supreme Court rules, it is Order 47. So when we file a review, and very often they are filed under Order 47, read with Article 137, as far as practical, will be circulated to the same judge of benches that delivered the judgment or order which is sought to be reviewed. Now, here, kindly note very often there are applications filed for recall and there are applications filed for modification of the order. Now, in what cases applications are entertained for recall, you will find there are some judgments of the Supreme Court where Supreme Court has said a recall is different from a review. A recall is, for example, an order is passed in violation of principle of natural justice. A party was never heard. Then you will file a recall application which will be heard in open court and the order will be recalled. It is not a recall. It is not a review on merits. It's a recall application. Similarly, recently, Supreme Court has held that in exceptional cases, you can ask for modification of the order. What are the exceptional cases? If the order which was finally passed was executory in nature and it is not capable now to be finally executed. Let us give an example. For example, if the order said that the purchaser will sell a plot of land, or sorry, purchaser will purchase the plot of land and seller will sell the plot of land upon a consideration to be paid by the purchaser. A final order is passed by the Supreme Court. After the order is passed, the land is acquired by government under the land acquisition proceedings. So that situs has gone. In such case, the order is not executable. The Supreme Court says you can move a modification application. Only in such exceptional cases, a modification application can be moved. Now, a curative petition is a petition under Order 47, which is circulated and heard by a bench of 3 senior most judges and judges who pass the judgment or order complained of, if available, unless otherwise ordered by the court. A curative petition shall be disposed of by circulation without any oral arguments. If the bench before which the petition was circulated concludes by a majority that the matter needs hearing, it will be listed before the same bench as far as possible. Now, if you see the rules, it provides a procedure that it has to be certified by a senior advocate as well as by the advocate on record that it is fit case which requires filing of curative petition. So these are various benches which are constituted to So we discussed the note so that it is helpful for the friends in the upcoming exam. Now I want to just broadly discuss what would be the syllabus which should be read. Of course, Constitution of India and certain provisions of Constitution of India, the Supreme Court rules of 2013, one must read threadbare, including amendments thereto. And I strongly suggest, please read, there is a book authored by our Attorney General on practice and procedure, Mr. Venkatramani. Very detailed, very good analysis. If you read the book, it will definitely be given you advantage. And of course, please read recent judgments passed by the Supreme Court, or leading judgments, landmark judgments on the role and responsibility of advocates, advocates on record. This will help in answering many questions. Also, there is a handbook of practice and procedure. You will find handbook in the Supreme Court website. You may download the handbook and read it. That will be of helpful. Also, I suggest you please read certain legal maxims or jurisprudential definitions. Just to name few, for example, approbate, reprobate, res ipso loquitur. Then we have many such repeatedly used phrases. ratio decidendi, obiter dicta. So kindly go through a few of them that may be of help. And before I conclude, I would like to share the pattern of the paper. So we have suggested, and it is subject to final confirmation, but we have suggested that there will be 2 questions of 15 marks. So we expect a little lengthy answer. And if you can support with some case laws, that will be an additional advantage. There will be 2 10 marks question. So that makes it 50 marks in all. And then there would be 10 5 marks question. There would be some options given. Most of the questions are example based. They are analytical questions. So if they are questions based on your concepts. So if your concepts are clear, this will be a scoring subject for you. So with this, I think I have taken enough time. I was told that I should complete my lecture in 45 to 50 minutes. So I've stick to my guidelines, my deadline. So I think I saw a lot of requests for sharing of the note. So I will suggest if it is possible, I will request the Supreme Court Registry to share if it is possible. Otherwise, I will ensure that in some group it is shared if it is helpful. So thank you very much. And with this note, I wish all the candidates all the best, do well, score well, and good luck. Thank you very much. Sir, we can end the lecture now.